You're listening to the American Democracy Minute, keeping your government by and for the people. In May, the Eighth Circuit Court of Appeals ruled that individuals, in this case Native Americans, do not have a private right of action in voting rights cases. An emergency stay was granted July 22nd, and it's likely headed to the U.S. Supreme Court. In 2021, the Turtle Mountain Band of Chippewa Indians, the Spirit Lake Tribe, and individual Native voters negotiated with the state of North Dakota to create voting districts that didn't dilute Native voting power. But after a 2023 Eighth Circuit decision in Arkansas, the state of North Dakota reneged on its deal with the tribes. That decision said only the U.S. Justice Department, not individual voters, could bring suits to enforce the provisions of the 1965 Voting Rights Act. In actuality, since 1965, individuals brought 90% of VRA cases. May 14th, a three-judge panel affirmed that individual voters cannot bring VRA cases, but it applies only in the Eighth Circuit. July 15th, the tribes and individual Native voters asked for an emergency stay from Justice Brett Kavanaugh, pending a full U.S. Supreme Court appeal request. The stay was granted July 16th. On the one hand, decades of precedent allow individuals to bring such VRA cases, but this High Court's conservative majority often ignores precedent and seeks ways to neutralize VRA protections for minority voters. We have more at AmericanDemocracyMinute.org. I'm Brian Beal.